Morning, everybody, and welcome to hearing 25 in relation to the Tuakau rezoning proposals. Just by way of introduction, before we start, I'll ask the panel to introduce themselves. Then I'll run through a few procedural things, and then I'll ask everybody else that's present to briefly introduce themselves, and when doing so, if they've got anything that they need to raise with us before they start, they could do that. My name is Phil Mitchell. I'm an Independent Hearings Commissioner and I'm chairing today's hearing.
Good morning, I'm Janet Gibb, Councillor at Waikato District Council and Independent Appointed Commissioner.
Good morning, I'm Diane Fulton. I'm an Independent Commissioner and I was a former Waikato District Councillor.
I'm Morena Jan Sedgwick. I'm a current Waikato District Councillor and appointed as an Independent Commissioner.
Morning, Nakato. Oh, you go, Will.
Will Marg, Independent Commissioner.
Linda Tiaho, Independent Commissioner.
Paul Cooney, Independent Commissioner, Deputy Chair and Lawyer.
Thank you, everybody. And as I say, we'll go around the room in a minute, including with the council staff and team, but just a couple of things by way of introduction. The first thing is to note is that the panel are now old hands at Zoom hearings, and we've got our system pretty well organised, we think. That's aided considerably by the pre-circulation of information that has been provided to us, all of which we have read. As per the directions that we issued some time ago, all that information, legal submissions themselves, evidence, rebuttal statements, etc., are to be taken as read. We are looking for people to provide short, sharp, sweet summaries of what it is they're concerned about, and in particular, what it is they're seeking from the panel by way of a decision. It's not helpful to us for people to read out vast tracts of the material that we've already read. It's just not an efficient use of time, and it doesn't actually help us in coming to a decision. So we're asking people to try and stick to an approximately 10-minute maximum presentation period. That's not to shortchange everybody. It's simply so that we can focus on what it is you specifically need to tell us about the outcome that you're seeking, as opposed to reading verbatim a whole range of material that we've already read before we've started today. The second thing I just want to note is that there'll be a few people in this process that are probably a little bit nervous about presenting to us today. They don't do this as part of their day job. Please don't be intimidated by the process. We will be simply asking people to provide their summaries to us, as I've alluded to. If the panel has any questions, we'll ask them. Those questions will really only be questions of clarification, just so that we understand exactly what it is that's being sought or why, and those sorts of things. We're not interested in putting people on the spot and making life uncomfortable for them. So if you are new to this game, or you haven't done it before, or you're a layperson, please try not to get too stressed or worried about how the process might go, because that's not our intention to intimidate anybody. I think that's probably all we need to say by way of introduction, other than to note that various of the panel have associations of some sort or other, in some cases with people that are making submissions on the plan. That's inevitable. As a consequence of that, there may be times during the course of the hearing when one or more of us take no active part in listening to particular submissions. And if that's the case, we'll be making, or those particular individuals will have no part in the decision making involving those submissions. I just want to make that point very clear, and we'll identify those panel member by panel member as and when they arise during the course of the hearing. The only time constraint that we don't impose on people relates to the presentation of the council's section 42A report. And the reason we do that is that because each one of the presenters only has to deal with their own topic, the section 42A report has to deal with all of them. And it's very hard to summarize a summary down to 10 minutes. We don't think that does justice to the presentation of what we need to hear. So we'll let that play out as it plays out, but everybody else, it would be appreciated if you could keep as close as possible to that 10-minute timeline, please. And I think without further ado then, unless there's anything from anyone else from the panel that we need to raise, which I don't think it looks like there is. So I think we'll just ask the council team to introduce themselves, please, as well as all the other parties that are present. And if I could also ask you that when you have finished speaking, if you could turn your microphone and video off, that just keeps the bandwidth available for those people that are talking. So people will be able to hear and see what's going on, but we won't be able to hear or see them. That, as I say, that just makes the reception and so forth a little bit more straightforward. So without further ado, if we could just go around the room, please, and do some brief introductions. Starting with the council team.
Morning all, Richard Bell here, District Plan Administrator and Hearings Coordinator for Council. Thanks.
Morena Sandra Kelly, Waikato District Council.
Morena Jane McCartney, Tuakau office, just observing, thanks.
Morena, can you hear me?
Yes, thank you.
Oh, sorry, I had mute problems. It's Chloe Trinaut here from Hillian Cooper. I'm the 42A reporting planner. Thank you.
Morena Koto, I'm Carolyn Rare, Assistant Counsel.
Good morning, everyone. Adam Jelly, Planner, Assistant Counsel.
Morena Tajit Hida from the Ngāruahi office, just observing.
Thank you. I think that's the council team. So if the submitter folk that are here could briefly introduce themselves, that would be helpful. Thanks.
Yeah, could you use that? Daniel Stanley here for 2 Sen and Tuakau Estates. I also have my submitter team in the room.
Thanks, Mr. Sadlier, and welcome. Just you appear to have a little bit of feedback on your system somehow or other, so you might be appreciated if you could perhaps work on that. We can hear you about 15 times.
I think we may have that resolved now.
That has. That's fine. That's good. Thank you.
Would you like me to run through the witnesses, sir, or?
No, we've got that list. Thank you. They're not on screen. If people are here individually and we can see a screen with their name on it, it would be helpful for them to.
What we're planning.
Pardon?
We're planning, sir. Can you turn the sound off on that one? Just this.
We'll come back to you, Mr. Sadley. While you sort that out, we'll go around the rest of the room and come back to you in a moment.
Morning, Commissioners. Leo Hills here for part of the Tuakau Estates team. Traffic.
Yeah. Thank you. Morning, Mr. Hills.
Hi, I'm Aaron Gray here, planner on behalf of Michael Shen.
Yes, thank you very much. Welcome, Mr. Gray.
Morning. Oh, where you go? Sorry. Good morning, sir. Julian Wilson, representing Louise White and Sarah White.
Thank you.
Heather Guire, witness.
Thank you, Mr. Dawson.
Good morning, everyone. Nick Hall and Sam Sugar, representing CHS Enterprises and James Lynn.
Very good. Thank you. Good morning.
Good morning.
John Oliver here, representing Kirrimura Trustee Limited.
Thanks, Mr. Oliver. Good morning.
Morning.
Good morning, Renee Fraser-Smith, representing Vanderbrink Group.
Thanks, Ms. Smith.
Morena panel, it's Peter Fuller representing Middlemiss and the Buckland Group.
Thank you. Good morning, Mr. Fuller.
I'm hoping my issues have been resolved, sir.
Yes, they have, by the sound of it. Thank you.
Excellent. So we have most of our expert team, bar Mr. Hills, in the room here, and our plan is to play a bit of musical chairs. So when people are presenting, you'll be seeing their face on the screen. So I have Ms. Sen, Ms. Hebblethwaite, Mr. Hegley, Mr. Curtis, and Mr. Alderton here with me, and Mr. Hills separately.
Very good. Thank you, Mr. Sadler. We've also got Ms. Williams present, not saying much, and I'll get this in advance. Ms. Williams acts for Tuakau Proteins Limited. Looks like she's having computer issues by the look of things. Ms. Williams is part of the Mitchell Dash team, of which I am a part, as declared in our register of interest. So I won't be taking any part in the consideration of Tuakau Proteins submission, nor that of Mr. Dawson's clients, who are on opposite sides of that same debate. So I'll just get that in now, and I've just had a note on the screen from Ms. Williams. It's having some sort of computer difficulties. I don't know what those are. I think that's everybody. So we'll kick off with Ms. Trenuth presenting a summary of the staff section 42A report, please. Thank you, Ms. Trenuth.
Good morning, panel and submitters. So I was just going to talk to my opening statement just to try and touch on the key points. Now I have in there are a number of maps, and I have prepared a bit of put them on PowerPoint so that they can be put on screen if we want to look at them and actually look at them as a larger image. So the one that I think I might talk to is probably the figure 5, which identifies all the various submitted areas.
That would be really helpful, I think. Thank you.
Okay, I'll pull that up in a second, but I'll just do the intro to start with. Okay, so just in terms of context, so obviously, well, first of all, obviously I wrote the section 42A report and the rebuttal report and the supplementary rebuttal statement in response to the late evidence in relation to the Tuakau Properties Limited site. So in terms of context, Tuakau's at the northern edge of the district. It's close to the Auckland regional boundary and is sits between essentially significant growth areas at Pukekohe and also Pocono. Moving down to paragraph 3, there's been steady growth at Tuakau, and that's anticipated to continue, but it's not as significant as the growth that's been experienced in Pocono. I won't go through the geographic description unless you want me to.
No, I think that's okay. Thank you.
I think then the next key matter is at 5 in terms of the Tuakau structure plan. So that was adopted in 2014 and was undertaken to assess how Tuakau would grow and to accommodate an additional population of 5,000 people. The structure plan proposes growth across 3 stages to 2046 and includes low density residential, rural residential and industrial land. Whilst the structure plan remains relevant because of the technical analysis and the community engagement undertaken to develop that structure plan, this document is now getting quite old, and it was prepared before the release of the NPS urban development capacity. And of course, now we've got the NPS for urban development, which changes that slightly. So this recent information demonstrates that the growth, the demand for growth has actually changed, and therefore the staging of the structure plan is out of date. So I don't think the technical analysis that sits behind the growth is out of date, but the timing for when growth needs to be brought forward is the main thing that sort of has shifted. So overall, the proposed district plan zoning generally aligns with the structure plan, bringing most of that growth forward. So I'll just pull up the, I'll just share the screen in terms of the zoning requests now. Hopefully that map, figure 5, is clear.
Yes, it is. Thank you.
Okay, so I'll just refer to those areas as I talk through the submissions. Moving into the summary of the statutory framework, first of all, it's important to recognise that Future Proof 2017 does identify indicative urban limits for the township, and that covers much of the, that covers a bit of an area a bit bigger than the structure plan. And then there's been work since the structure plan, and as part of Future Proof 2017, the North Waikato Integrated Growth Management Program, which looked to increase the population by 15 to 20,000 residents. And then on the next page, paragraph 12, the framework report also talks about the growth for Tuakau, which is generally consistent. So looking at about 6,000 dwellings. Waikato 2070 identifies several growth cells, and most of those are available in the medium term, with only the Buckland growth cell. And rather than swap the figures, I'll just note that the Buckland's growth cell is on the western edge of the Tuakau township in terms of the proposed zoning map. The Dromgore's road growth cell is identified as a priority area. That's this area to the south over here of the existing township. So the paragraph 15 and 16 really address development capacity, identifying that there is a shortfall in supply in the short term, 1 to 3 years, of approximately 730 dwellings when you look at the notified district plan. And so therefore additional growth or rezoning is required to meet the requirements of the NPSUD. So that leads into some of the recommendations. So turning to the key recommendations, first of all is area 1 here at the northern edge of the township, which is zoned residential in the notified plan. There are a number of submissions opposing the zoning because of reverse sensitivity effects to the Harrisville motocross track, which is west of that area. Looking at the work that was done in the Tuakau structure plan, the reverse sensitivity issues had been acknowledged both to the Harrisville motocross track and also the horticultural activities of turners and growers. We've got large glass houses, not just almost immediately north of that area. And they had proposed, and the structure plan had identified that area 1 would have some residential zoning, but there would be a buffer around it to manage that reverse sensitivity effect. So therefore, I've recommended to rezone the northern part of that area 1 from residential back to rural production zone. The next area in terms of recommendations is the village zone around identified as 2 in this map, so around the Percy Graham Drive, Johnson Street, which is west of Harrisville Road, and then also around Barnaby Road to the east of Harrisville Road. Submitters sought that the zoning should be residential and that the village zone wasn't a efficient use of urban land. And basically, in looking at the village zone, I had considered the work that was, the assessments that were undertaken by Mr. Cleese in terms of the hearing for village zone, where he raised concerns about the difference between what I call the operative village zone and the new village zone, which function quite separately, and also Mr. Cleese's Section 42A report for these hearings in terms of the potential for a future urban zone. So my recommendations are that I support the village zone in those areas where they were previously rural residential in the operative plan because of topography and geotechnical constraints. But I support the rezoning of the new village zone to future urban zone because those areas have been identified as future growth areas, and structure planning will be able to coordinate the existing infrastructure constraints and will be able to determine appropriate densities at that time. Moving to the next area. Kāinga Ora made a submission seeking medium density residential zone, and these are identified as 7. So basically these areas surrounding the town centre. These submissions were generally supported, and the only difference was that I didn't support including the Tuakau, sorry. Sorry about that.
Right.
Lost my mouse. There we go. The just on the western edge on Buckland Road is the Tuakau Primary School, which was included by Kāinga Ora to be identified as medium density, and I've just indicated I don't believe that's necessary, given there's not really any development capacity added, and it doesn't compromise a sort of consistent approach to zoning because it's on the edge. The next area is what I call Gerrity Road, I think it is, in Area 9. So this area is not included in the Waikato 2070 growth areas. It is partially within the future-proof 2017 indicative growth, urban growth limit. The reason why it's been excluded from the growth sort of approach in the Tuakau structure plan was because of reverse sensitivity effects associated with the Tuakau Proteins Limited site to the south here by the river, and also there's the EnviroFert waste management site around here in between there as well. So the submitter had provided evidence in relation to air quality and noise to demonstrate that the reverse sensitivity effects could be adequately managed, and that the site is appropriately located in terms of meeting a compact urban form and being good for growth, urban development, basically. So I support the land being identified for urban growth. However, Watercare has advised the council that Three Waters infrastructure is not suitably planned. So therefore, I've recommended a future urban zone. The submitter is concerned that the reason why there are no Three Waters infrastructure planned is because the land isn't included in Waikato 2070. So it's a bit of that's what I call a circular argument, because if it had been identified, then there would be zoning, there would be infrastructure planning. So I'm sure Mr. Oliver will address that issue in some detail. So what I've said is I think the future urban zone is appropriate. The structure planning process will be the appropriate way to address those infrastructure issues. The next area is Dominion Road. Number 6. The front of these sites was zoned residential, but the backs were retained as rural because of potential reverse sensitivity effects associated with the industrial area to the south. Again, the submitter provided technical evidence in terms of noise and air quality, indicating that reverse sensitivity effects could be adequately managed. And the submitters proposed an amenity yard along that southern edge to ensure that future development is appropriately designed to avoid those effects. So I support rezoning that area residential. The next key area is area 14. Oh, hang on a minute. Sorry. No, sorry. The next area discussed in my summary at page 38 relates to concerns about the zoning of this Buckland growth area on the western edge of Tuakau. Now, I haven't identified that as a specific rezoning request because the submissions were more of a general description, but as I worked through those in terms of concerns that Horticultural New Zealand has raised around productive soils, it's become evident that this area has been zoned residential too early because there are concerns about infrastructure, but it has been identified in the structure plan as being appropriate for growth. So there is a tension in this area between soils and growth, but in my view, the structure plan has made that strategic decision that although it does comprise high quality soils, it is an appropriate place for urban growth. So that that decision has been made in my view. However, in terms of the live zoning, there are significant constraints around infrastructure, need for three waters planning and also transport connections. So therefore it's appropriate in my view to zone that area future urban zone to enable those issues to be addressed through structure planning. So those are the key recommendations in terms of rezonings. Then I'll go through now the remaining or sort of key matters of contention. So the first one is around the Tuakau properties site. This is identified as number 11, adjacent to the Waikato River. It's zoned industrial in the proposed plan, and submitters are seeking a Tuakau Properties Limited, the landowner, supports that zoning, but a number of submitters in the area oppose that zoning and seek a business zone largely because of concerns around historical performance of the site and in terms of odour and noise, and they consider a business zone would be better at avoiding some of those effects. However, in my review of the plan, the operative plan, my feeling is that the industrial zone is the most appropriate zone. I think the submitters have picked up on the fact that it was zoned business under the operative plan, but the industrial zone under the proposed district plan is the most consistent sort of comparative zone, I think, to what the intention of that original zone was. So I don't see there as being a major shift in terms of the change in zone. But I do think that if you were to zone it business zone, you would see quite a significant change in potential outcomes on that site because of what you could achieve under a business zone compared to industrial. So I haven't supported any change on that zone, on that site. The next area of contention at paragraph 47 of my opening statement is the eastern end of Dominion Road. I've labelled 4 on this map, currently zoned rural. There are 2 submitters that are seeking sites on the very edge of the existing urban area above the village zoning. Here is the submission sought village, consistent with what these zones were proposed, but I note from their evidence, I think they would also accept a future urban zone, which would be consistent with what's recommended for the adjacent area. I've considered the technical analysis and the structure plan when looking at this site, these particular 2 sites, and consider that it's not appropriate for urban development because of topography, landscape and geotechnical constraints. I think these constraints will make development to an urban density and provision of articulated infrastructure more difficult. Therefore, in terms of, whilst I acknowledge that you may be able to get some development on there, it's not going to provide a significant amount of development capacity in terms of assisting the council in achieving its requirements under the NPS urban development. So I don't believe it's necessary. I prefer, then the other issue that you've got to consider on these areas is where a defensible boundary is, and when you start to extend along here, how far do you go? I acknowledge that the submitters have identified a defensible boundary of property edges of the property. Sorry, the edge of the property to the north, which also forms a low ridge, so it could be considered to provide a defensible boundary, but I prefer the notified boundary along here, along the current extent, which follows a stream. The wider area of 4 beyond those sites reflects the Horticulture New Zealand submission. That said, if you take away the residential zoning in Buckland, you could put it in this area, which doesn't have high quality soils. The next area, key area in contention, is identified as 14. This is the area sought by the Buckland Country Living Zone Landowners Group. That's approximately 400 to 450 hectares of land that's currently zoned rural. It's on the edge of the regional boundary, the district boundary, and adjoins the future urban zone of Tuakau and Buckland. So the submitter sees it as being a logical sort of a transitional zone, I guess, between that urban edge and the rural productive land within the Waikato district, and that the high quality soils that exist are fragmented and therefore no longer productive. So countryside living, in their opinion, would be a good outcome. In my assessment, I do not support this outcome, mainly because there's sufficient countryside living within the district, as expressed in the rural hearing. And so there's sufficient, only 20% of the district's growth is expected to occur outside of existing urban areas, and more than that is provided throughout the district. The proposal would result in further fragmentation of underlying high-class soils. And also, I think that, in my opinion, the scale of countryside living and its proximity to Tuakau would increase the pressure on infrastructure services and amenities, which has not been really assessed in the submitter's evidence. So I support retaining the rural zone on that land. The next key area in contention is Whangarata Road, which is identified as number 8, currently zoned industrial, and the submitter seeks to zone the front part of their site at 115 Whangarata Road to residential. The identification of this land as industrial is consistent with the Tuakau structure plan. Key concerns I have with the relief sought by the submitter is that the very frontage of this site, 113 Whangarata Road, does not appear to be identified within the scope of the submitter's relief sought. They've specifically sought rezoning of 115 and do not appear to have included 113, although I do note that some of their concept plans and their evidence did include 113. But from what I could see, the submission itself did not specifically seek to include that, although it would make logical sense if you were to rezone that site, that should also be included because it's a very unusual shape and would be a strange isolated industrial zone surrounded by residential. So that's one reason. The other issue is, the key issue is reverse sensitivity. The submitter has demonstrated that there is a defensible boundary of a stream along the northern edge of the area they seek, but there are gaps, in my opinion, around how you'd manage the interface between residential and the industrial zone that they would be creating, that the new interface that they'd be creating. I prefer the notified extent of zoning, which relies on the Kairoa stream and Esplanade reserves along the eastern boundary to provide an effective buffer. So I think it's a stronger boundary or buffer to manage those reverse sensitivity effects. I also consider the 19 hectares that would be lost by rezoning it to residential to be significant in terms of the district's industrial land supply. However, I acknowledge that there is an identified surplus of industrial land at Tuakau, but that the industrial land at Pocono has largely been taken up. So therefore, it's unclear whether there really is a surplus at Tuakau. So I support retaining that land as industrial. The next issue is at Riders Road. It's hard to see in this map. It's number 2. It's a very small area. Sorry, not number 2, number 3. This relates to the industrial zone where the Vanderbrink chicken processing sites are. And this is a little bit similar to the Tuakau protein site, where the site was zoned business under the operative plan. And in terms of rolling over the zoning, it has been identified that industrial zoning is the most similar. The submitter is concerned that the zone or the land shouldn't be zoned based on existing use and should be based on best zone for the location, given that it's adjacent or in proximity to the town centre. I do not support, I support retention of the existing zoning as industrial because the area is somewhat severed from the town centre, so it doesn't function. It's severed by the railway line to the south of the business area, the railway line to the north of the town centre, and then the Riders Road area itself is also severed from the wider area by a large stream. So it's quite an isolated pocket of land. There's also the intersection of Riders Road and Harrisville Road is very close to the railway level crossing, and potential impacts on that haven't been considered. And then I also think that a business zone would not be compatible with this area because of the types of activities that could be enabled through that zone. So in conclusion, the recommended changes that are proposed in my Section 42A reports will provide some additional development capacity. In the graph at paragraph 59 of my opening statement is provided from the framework report that Dr. Davey presented, showing that development capacity will meet demand and the NPS UD requirements in the sort of medium term, and therefore I do not consider any additional capacity is required. I'm happy to take any questions.
Thank you, Ms. Trinath. Let's see if there are any questions for you. Can we start with you, Ms. Gibb, please?
No, very thorough report. Thank you. I have no questions.
Ms. Sedgwick?
No, nothing from me. Thank you.
Mr. Marg?
No, nothing from me. Thank you.
Mr. Fulton?
Yeah, just one question, please. On your graph, the last one, showing the in Tuakau, you're showing the demand plus 20%, and then the net total, which is the recommendations. There appears as if there is still a very large surplus available in Tuakau to grow without, and then there's a very large hectares of land that is currently being suggested should be further urban growth zones. Is that correct? Have I read that correctly? That there's still going to be a large surplus of land unless Tuakau grows much faster than can be expected?
So yes, the figure shows that the proposed district plan with recommended changes would provide sufficient. I don't know whether it would necessarily be considered a large surplus because there's always an element of feasibility in terms of whether development will actually occur in those locations. So there's, if you see the 3 bars, the first one being demand, the second one being what's proposed, and then the third one showing what's feasible. So there is still a surplus, but it wouldn't be significant. I think the issue is probably more in terms of the short term, which isn't really reflected in that graph because the graph looks at 2021 to 2036. So even though in the medium term there's land coming on stream, there is potentially still a shortfall in terms of the next 1 to 3 years.
Okay, thank you. And just on the industrial area, and I read in your report somewhere, you said that there was seemed to be a slow take up in the industrial area, and there's a large amount of industrial area land available there. Just looking at it from a district-wide perspective, and Pocono is almost in the reverse of that of having industrial area available. Do you see that's a possibility that people from Pocono may use up some of that land and travel?
I think it is possible. It is difficult to know because the land at the industrial land at Tuakau has been there, been available for a while. But I can see that Pocono would have the land that was available at Pocono would have been more attractive because obviously it's located closer to the motorway. Given that that land is now taken up, I think there is potentially potential that the land at Tuakau may start to be taken up. Other issues as to why it hadn't been taken up previously, relates to some of the inconsistencies in zoning. And so sometimes this sort of land does take a while to get going in terms of market take up, but the identification of industrial land or retention is a difficult issue. That's always in a location that could be better suited for something else. So therefore, if you say that the market's not going to go there, and so therefore it's better used as residential, then you potentially end up chipping away at your industrial land supply, which is not easy to replace, whereas residential tends to be much more easier to find an alternative location. I don't know if that answers your question, but
no, thank you for that. No, happy with that. Thank you very much.
Thank you, Ms. Tiaho.
No questions from me, thank you.
Mr. Cooney.
Yes, I'm just taking up Mr. Fulton's point about that chart that you've got as a result of your 42A report. I wonder if we could stick it up on the screen.
I can just have a look and see if I've... Yep, I do have it.
Not so much that one, the one that you,
sorry.
Table 6.
Table 6. Table 6 in my 42A report. You mean? Yeah. Yeah. Oh, yeah. Okay. That one?
Yeah, that's one. Can
Okay,
you just scroll down a bit?
I'll just try and make it. Yeah.
So just as a summary of Tuakau, we've got at the moment a deficit of 730.
Yes.
Right? And what you're proposing by way of rezoning to meet that shortfall is we finish up with a surplus of 265. So overall, the capacity you're increasing by is about 1,000.
So
you've got a 730 deficit and you're coming into surplus at 265.
Yeah, so some of that surplus is what I'm proposing, which is the red, the 219 at Dominion Road and the 425 at Geraghty's, but then also some of the anticipated land that's coming through at already identified in the proposed plan. So that's the residential zone land at Dominion Road.
Oh, okay. Yeah.
And the infill development and the residential land at Dromgold. So the plan already had provided a stream of development capacity, but I've topped it up a bit by about 700 dwellings.
All right. Okay.
Also in terms of this table, I haven't got figures for the medium density because at the time of preparing this, I didn't know, hadn't had that calculated. I think Dr. Davies' analysis does include some capacity in terms of medium density. So that might be why his figure shows a bit more of a surplus than my table does.
Okay. All right. Just overall, has Tuakau met growth expectations predicted in the earlier studies like Future Proof 2017? Has it, in the strategic documents, has it met those growth projections, or is it lagging behind?
In terms of the scale of growth, terms of, yeah. Well, before the proposed plan, there wasn't a large amount of land that was identified for growth. The focus had been, Pokeno has really taken up the lion's share of growth in this part of the district. So I think based on what's been happening at Pokeno, but also what's been happening in Pukekohe, there is certainly demand or pressure for growth in the northern part of the district, which can be realised at Tuakau, and recognising that Tuakau has, all the basis, facilities it's been an existing town to support growth. In terms of whether the market is, whether it's feasible, as I said, it's just the market's been very focused at Pocono, so I'm not sure it has. It's not been identified as being a high area for growth. That's why the predictions were steady growth. So there'd be steady growth, but not the scale that you've seen at Pocono because of its location. But it certainly has capacity to meet that growth demand.
Thank you. Can you put back up your map of the rezoning requests?
Yeah.
Now, can you just explain the basis for number 2 there? Can you just, it's a little bit, I just found your description there a little bit confusing. So can you just briefly go back through that again?
I can. I wonder if I can make it, sorry, I was going to see if I could try and zoom into it. Going the wrong way. Sorry, just bear with me while I try and zoom into it a bit to make that so we can actually see that a bit better, because it is quite difficult to see on that map.
Ms. Trenus, I do have it on Intramaps if you would like me to bring that up.
Oh, yeah, that might be better actually. Yeah.
Just have to point me to whereabouts it is.
Sorry.
Can everyone see that?
Yep.
Yes, thanks.
Okay, so if you can move a little bit to the east, so Harrisville Road's kind of in the centre of the screen. Yeah, and down a bit, move down a bit further. Sorry, just move to Harrisville so that the town centre's down. Move that down. Yeah, down, stop. Yeah, that's so that now shows the village zone in that sort of northern part of the township. So the area to the west of Harrisville Road around Johnson Street and that other street, that's Johnson Street, and to the north is the road Percy Graham. So further north, that's the Percy Graham, I can't remember the exact name, Percy Graham Drive. So that all that area was previously rural residential in the operative plan. And the structure plan, Tuakau structure plan, identifies that as remaining as a rural residential type land use. The area on the west is it, so then the next part was the area on the west. So the bit that we can see where the cursor is, that bit, but sort of south of Barnaby Road, was also zoned rural residential in the operative plan. Maybe you could switch that on, Fletcher. And so you can see those areas essentially being rolled over into what's now the village zone. Yep. If you go back to the proposed plan and then move to the northern part of Barnaby Road, bring that down. Yep, there. So all of that village zone is what I call the new village zone. So that's been identified as village zone, but it's not the same as the village zone in the other areas, because this was identified as potentially an area for urban growth. And so that village zone has constraints on development until such time as infrastructure servicing is available. So that's the sort of two, and then the other area along Dominion Road, which it's got a different number to the east, other way. is also the new, that village zone is also part of that, what I call the new village zone, which was discussed at the village zone hearing. Does that make it more clear, Mr. King?
Yeah, I think so. I think I can follow that. But the areas where you've proposed to be future urban,
yeah,
can you show
turn
those?
Yeah. I have a map of them, Fletcher, if it's easier.
Sorry, what did you want me to bring up?
Are you able to bring up the recommended zones, the future urban zone, or do I need to find my map?
You might be best placed to find. Sorry,
that's fine. I'll do that. Sorry, bear with me. Share screen. So this slide shows on the left-hand side the proposed zoning, and then on the right-hand side, left-hand side is the notified zoning, and the right-hand side is the recommended rezoning to future urban.
So what's your main reason for that land not coming in as, instead of future urban, being converted to residential?
Because of infrastructure constraints. And
it's the chicken and egg situation.
Well, no, this one's not so much the chicken and egg, because the Waikato 2070 had identified these to be, I guess in the medium term. So not the long term, like the Bucklands growth cell, and not completely excluded like the Geraghty Road example, but just that there are some upgrades that are required to service these areas in order to get the most efficient urban development, when they're developed.
Yeah, and if that was to be future, to be zoned a live zone residential, how many lots would be realised?
Well, I don't actually know, because we don't know what the capacity is we don't know what the type of, I guess if you put the residential zone on, obviously you could do a calculation based on the minimum site area of, I think it's 400, but the land does have, is quite sloping. So I'm not sure whether that would be a reasonable estimate. So in the structure plan, Tuakau structure plan, it had originally been identified for rural residential, but I think what we're acknowledging is that that's probably not the best outcome, but it might be somewhere between a standard suburban residential zone and a rural residential. And I think that really needs to be worked out through structure planning, and then you can determine what the impacts on infrastructure servicing would be to enable that to be serviced. So I haven't actually worked out the capacity of that from a if we were to change it to residential, there would be some capacity identified as the village zone, but I'd have to find that for you.
Okay.
It might just be as a starting point indication.
Just going to the Geraghty Road, Buckland Road area there, that area you've proposed to be future urban, is that right?
That's correct.
What weight did you give to the protection of high class, productive soils and high class soils?
So in terms of that Bucklands area in particular, which is the larger area, and it's currently in horticulture, and is the area that Horticulture New Zealand have raised concerns about. I acknowledge that they are high quality soils and that ideally you would protect them. The issue is it's right on the edge of the existing township, and therefore is also a ideal place for expansion. So you've got to figure out how to manage that tension. Do you protect the soils or do you provide for growth? I haven't made that decision myself, because in my view, the Tuakau structure plan has already made that decision through engagement with the community in consideration of what's needed in order to accommodate growth. So the structure plan has already determined that that area should be would be better or more efficiently used for growth, and that area is also in the urban limits for Future Proof 2017. So in my view, that strategic decision has already been made.
Nothing in a structure plan is cast in stone, though, is it?
No, but the structure plan, you've got to, when you've got those two competing, tensions, you've got to undertake some analysis to figure out which one is the, which way you're going to go. At this stage, there's the structure plan indicates that that would be appropriate. Now, I appreciate in light of if we had a NPS for highly productive land, that might be more difficult, but even that identifies that where a council, where a local authority has identified an area as appropriate for urban growth, that protection is would no longer necessarily be in play. So even the discussion document on highly productive land recognises that those trade-offs will need to be made in some situations.
The structure plan was done when? 2016?
Yes. 2014.
14. Okay. Thank you.
Thanks, Mr. Kearney. Just two very quick ones from me, please, Ms. Tranau. The land at 113 Whangarata Road, you've mentioned that and the land adjacent to that at 115 are being treated differently, and I understand that point. But are they owned by the same landowner, or are they separately owned? Do you know?
I don't know.
It's not clear from Mr. Oakley's evidence.
No, I think
I'll ask him. I just thought you might have known.
No, sorry, I didn't specifically check that.
No, that's okay. I just wondered.
Yeah.
Probably a slightly more substantive question. You made mention in your summary, and you have addressed it in your written report in a bit more detail, but I think it would be helpful for you to expand a little bit about your chicken and egg comment. You made mention that Mr. Oliver would be addressing it in more detail, and I've read his evidence, obviously.
Yeah.
But could you just elaborate on that a little bit more and really explain why, in your opinion, a future urban zone with a structure plan to follow is a better outcome than structure planning now, because some of the submitters have provided a structure plan, but there is no actual provision yet for infrastructure. I mean, I understand the tension between the two, but could you just explain your logic a little bit more fully, please?
Sure. I'm just having a quick look at where my rebuttal addresses this issue, just to refer to.
I just think it's only, well, it's probably appropriate for you to, I mean, it's written down, but I think it would be helpful for you to, before Mr. Oliver does give us his view, it'd be good to hear from you.
Yeah, so essentially, my understanding is from discussions or information from Watercare is that their three waters planning, particularly water and wastewater, is based on the Waikato 2070. And so they've identified what's required to service the Dromgool's road growth area. And I believe that provides for, I don't know, roughly off the top of my head, 550 dwellings in that area. And so that area is identified as being a priority growth and investment area in the Waikato 2070. So that's basically saying that should be, short-term sort of going ahead, servicing that. The concern is if you then live zone what's essentially the western side of Gerrity Road, opposite the Dromgool growth area, you may be able to service that, but that will potentially be taking the capacity away from an area that's been identified by the council as being essentially development ready.
No, I understand that part. What I don't quite understand is how a future structure plan would actually solve that problem.
I don't,
because it was presumably by that time Watercare would say, well, we still haven't planned for that area, and it's still a black hole.
I think by identifying it as future urban zone, what you're doing is you're recognising that it actually is appropriate for urban growth. Therefore, essentially the Waikato 2070 should be updated to then include it and identify the timing of that, which would enable infrastructure providers to factor it into their planning.
Okay. All right. I certainly understand the rationale you're explaining. So thank you, Ms. Trenouth. That's very helpful. Thanks for your various reports and summary.
Thank you.
Which brings us to Tuakau proteins, which I've also mentioned previously I won't participate in. Mr. Bell, I'll turn my microphone and video off. If you could text me when the submitter and the one following Mr. Dawson's clients are finished, I can resume at that point. Thank you.
No worries, can do.
All right. Who's representing Tuakau Proteins Limited? Ms. Williams, is that right?
I believe Miss Williams is, but I think she's having technical problems.
Oh, okay. Oh, here she is. Miss Williams, you're representing Tuakau Proteins? No, we're not. No, we're still not getting you.
Ms. Williams, if I may suggest, possibly connect through your phone as a possible option.
Can you hear me now?
Yes. Yes, thanks.
Can you hear me?
Yes. Can you hear us?
I don't hear me.
Fletcher, can you go back and tell her we can't hear her at the moment? We did just a few minutes ago.
Can you hear me?
Yes.
Oh,
yes.
I apologize for that. I'm not quite sure what's happened to my computer this morning. I never have problems. And then, of course, when I need it, I was running into problems.
All right. It's good.
Nikki Williams from Tuakau Protein. As the chair mentioned this morning, my evidence will have been read, so I won't read through it, but I will just quickly cover off the points. My evidence is in support of the industrial zoning for the Tuakau Protein site in Lackwood Road, Tuakau. And previously, I have presented evidence to the hearings panel relating to the industrial zone back in 2019. I have read the Section 42A report and also the rebuttal evidence from Ms. Trenuth, and I take on board the comments and her recommendations in that report. The Tuakau protein factory was established on the site back in the 1970s, and it has various resource consents from Waikato District Council for the buildings and operation of the site. And it has recently obtained a air discharge consent from Waikato Regional Council. That consent is a relatively short-term consent. They've been granted a consent for 2 years. And as has certainly been noted by the submitters in their rebuttal evidence, the site, and I'm sure you're all very aware of, was subject to a significant fire in March earlier this year. So the owners of the site are currently working through a number of issues on the site and will be working with the Regional Council and District Council in relation to the rebuilding of that factory. But the recent consent from Waikato Regional Council does require significant mitigation of the site to ensure that the odours, which has been the long-standing issue from the site, are contained within that site. Just a little bit of background, and I know Ms. Trenuth ran through that. The site is zoned business in the operative district plan, and that business zoning is quite unique in that it does actually provide for the industrial activity on the Tuakau protein site specifically. There's a rule in the operative plan that specifically relates to those properties actually, through which a number of consents have been obtained. And also, I just thought I'd point out Ms. Trenuth in her rebuttal evidence referred to consideration of whether the rural zone would be appropriate on that site. That's not something the submitters have asked for, but I just note that in the very original submissions that TPL lodged on the proposed district plan, there was one that related to the definition of rural industry. However, that issue was not pursued through the hearings as through the industrial zone hearings. The applicants, you know, I recall at the time a discussion around the National Planning Standards definition of industrial activities, and TPL are confident that the activities of the site are more aligned to the industrial than an industrial activity than something that would now be in the business zones of the proposed district plan. Let me just see. And really, I guess when I was preparing my evidence, I went back and reread certainly the framework report that was prepared for the rezoning submissions, and certainly back through those Section 42 reports from the industrial hearings. And it's my view that the industrial zone is an appropriate zoning for this site, and that the business zone in the proposed plan is now intended to provide for a range of more commercial and business activities and not the activity that is operating currently on the site. I think that largely just covers off as a summary my evidence, but I'm very happy to take any questions if you have them for me. Thank you.
All right, thanks, Ms. Williams, for that. Ms. Sedgwick?
Thank you. I'm just wondering, Ms. Williams, is there a difference in your opinion in rural industry to regular industry, of what you would call normal industry, everyday industry? Do you see a difference in that?
Yes, I think the rural industry didn't include the element of processing, which is, and you know, the processing, which is the industrial activity that's taking place on that site. So the actual industrial processing. Rural industry is more about rural transport and those types of rural activities rather than actually a processing plant.
Okay. And I do realise about the fire. I'm just wondering, is any part of the plant still operating at the moment?
My understanding is that none of the plant is operating presently.
No, it was significant. Thank you.
All right, Ms. Gibb.
Yes, thanks, Mr. Chair. Ms. Williams, can you elaborate on the Regional Council consent regarding the air discharge, the mitigation proposed for containing the odours on site? What are the plans that your client has to do that?
So yes, so they've been granted consent from the Regional Council, and there's a number of conditions around an internal upgrade to the facility. Obviously, now with the fire, those were to be in place by the end of September this year to the existing plant. And basically what it was a system to ensure that there was no discharge to air from the processing facilities on the site, which, as you'll be aware, there has been an issue of unreasonable odour beyond the site. There's been a lot of monitoring. So they engaged odour experts who designed a new system to ensure that that basically the consent requires that there is no discharge.
Okay, so they're planning to have that installed in the rebuild,
yes, presumably.
And if they don't comply with that, what are the outcomes? Do you know?
Yes, the conditions of the consent are very specific about that, and they will, before they can operate, they will have to show that they can comply.
Yes, sorry, thank you for that. What I really mean is if even after that they don't comply, what are the outcomes?
So the council and the applicant have to conduct monitoring to ensure that they do comply, so that the issue of non-compliance doesn't occur again. So it's not intended that there would be, but there are a range of conditions. If there is non-compliance, then effectively they have to mitigate and ultimately stop operating if they can't comply.
Oh, thanks for the clarification, Ms. Williams, very much. Thank you.
Okay, is that it? Is that Ms. Skip?
Yes, thank you.
Okay, Ms. Tuakau.
Thank you. There's really strong submissions in opposition to the zoning of industrial, and in particular in relation to the operations of Tuakau proteins because of the proximity to the Waikato River. So are there any plans to relocate? Do you think it's the right thing to do to rebuild something that's so strongly opposed by the neighbours?
I can't talk for the company owners, but my understanding is that their intention is to rebuild that site. It does have, it hasn't been established there since the 1970s, and certainly they do hold the appropriate consents from the Regional Council in relation to any discharges from their site. Certainly, the industrial zoning links with the other areas. I think Ms. Trenuth pointed out that there were a number of sites that similarly had similar business zonings in the operative district plan that are now proposed industrial. So I guess it's similar to one of those other sites as well, that it now has that existing use and existing consents on the site as an industrial activity.
All right. Mr. Mark?
No, nothing from me. Thank you, Ms. Williams.
Mr. Fulton?
Just a question. If it was not changed to an industrial zone, effectively it would shut them down, wouldn't it? I mean, and that's the intention of some of the submitters is hoping probably for that, to be that decision. Have I got that correct?
They would have their they do hold existing resource consents for that site to operate. So effectively they would have that zoning, the business zoning, while the activities wouldn't be permitted under that zone. They would still have their existing resource consents that they operate, but they would have to rebuild exactly in line with that. Otherwise, they would be required to go back through the resource consent process, which, depending on the redesigns, it may well be that they will be into that space as well.
Okay, thank you.
Yes, just a couple of questions from me, Ms. Williams. If this is zoned industrial, does that allow your client to expand under a permitted activity situation?
The activity would be permitted, which is the advantage over it having a business zone. However, there's still the development standards that would apply to that site within the industrial zone standards that they would have to meet. So if they step outside those, then they will still require resource consents.
Yeah, all right. They have the existing use rights. They have the authorised consents. So whatever zone at the moment, they can keep operating. Is that
yes?
That's
yes,
the gist of your evidence.
Yes, that's correct. As long as it's in line with their existing resource consents.
And if they breach the consent, the terms of the consent, it's deemed an unauthorised activity, and they can be prosecuted.
Yes, that's correct. And yes, and unfortunately, they have had a number of issues with the site, and I'm sure you will be aware that they were prosecuted through the regional council in 2020 for a discharge that occurred at the very beginning, end of 1920.
Does the activity, does it discharge anything into the river at all?
Yeah, they have a wastewater treatment plant that it processes the discharge from the factory into a wastewater treatment plant that then ultimately does discharge to the river.
And that's subject to consent as well?
Yes, it's subject to consent, and that was also part of the air discharge consent application in relation to the odour control from the wastewater treatment plant. But the resource consents for the wastewater treatment plant is separate from the air discharge consents.
And how long has that got to go, do you know?
Off the top of my head, I think it's 2028, but I can just confirm that. I don't have that immediately in front of me.
That's all right. Okay, thank you, Ms. Williams, for that evidence. Thank you very much.
Thank you all.
Yeah.
I think the next submitter is Louise and Sarah White. Dawson, I think that's you.
Yes, good morning.
Good morning.
I've got Ken Maguire with me. So I'm sure the panel's familiar with my legal submissions and Ms. Maguire's statement of evidence. What I'd like to do briefly, if I could, is perhaps just tell you our position and address some of the questions that have just been asked by the panel. And I'm going to ask Heather, she would like to speak to you quite passionately as to her view of life. Look, our analysis is that the Tuakau protein site obviously has quite a tardy history of compliance. It goes back many, many years. As I've heard said by Nikki Williams, and I agree with her, it operates under existing use rights. It has a business zoning and at present, and it's been able to operate for some considerable time with that in place. The key issues here, though, sir, are that our reverse sensitivity in the sensibility of enabling really a facility like this to be able to expand in the future. It's right on the Waikato River, which is an extremely sensitive, iconic feature in itself, and it has a number of houses very close to it. I note in passing those houses of it were actually there, some of them, before the plant itself. So this is really a little bit unusual in that we've got the noxious, and offensive effects potentially of this activity coming into, residential neighbours. So our position is that, a business zoning actually does adequately recognise the activity. I acknowledge it does mean that if they wish to expand, they may need to get consent. But my experience of this facility, having been involved in it for a few years now, is that the real constraints here are in terms of noise and odour. And I'm not hearing anything that says that the noise controls of a business zone are restrictive and prohibitive of its current operation, or indeed if it wishes to expand. I heard Ms. Williams say in answer to a question, I think that the existing discharge consent requires that there be no discharge of odour. Sir, I wish that was the case, but in fact it's not. The discharge consent and indeed the Environment Court's enforcement order don't say no odour. They say there's a whole lot of things that need to be done, but that there can't be an offensive odour. So that's slightly different. Of course, my understanding also is that the recently approved discharge consent is for a period of 2 years. And that's because there are a whole lot of fairly significant plant upgrades that were required to enable the plant to meet any kind of sensible odour standard. So they operate, they would operate in due course under that consent. I heard Mr. Fulton make the suggestion that what the submitters are after here is trying to shut the plant down. With respect, the position actually is that we're obliged to recognise that the plant does have existing use rights, but we say it needs to be constrained, it needs to internalise its effects, and we need to recognise it has some significant sensitivity around it. And that's the reason why we say the business zoning is appropriate. And Sarah, in relation to your own questions, this discussion around existing use rights and the need to apply for consent, my basic understanding, and I stand to be corrected by anyone who knows better than I do, but if the plant wanted to expand beyond its current consent, then my understanding is the biggest hurdle it would face would be the odour discharge consents required from the regional council, given the scrutiny they've been under to date. Also, noise compliance. And my understanding also is that TPL have sought different noise standards in the industrial zone as it relates to the site, which would allow those noise standards to be higher. And that's part of the reason for our opposition.
That was raised at the earlier hearing, wasn't it?
I believe so, sir. I wasn't involved in hearing 7.
Yeah,
but
it was.
I believe so.
And I think we're still to make a decision on that. So
yes.
Yeah. Okay.
But that's one of the reasons for our opposition to an industrial zone, because if that noise standard were relaxed, it's not so much what we call the zone, it's more the performance standards that come with it. So my very basic understanding of this is that if the plant wanted to expand under a business zoning, it would be the bulk and location controls it would have to deal with, and really it's no different from the significant hurdles it faces under the odour particularly, but also the noise. So all in all, sir, my view is that, you know, this facility has existing use rights. It has to deal with its odour. A business zone is actually an appropriate way of dealing with reverse sensitivity and recognising the sensitivity of the surrounding environment. That's my position. So perhaps if I could invite any questions on that, and then I'll ask Heather to speak to you if she may, as to where the community is coming from on this.
All right, I'll perhaps it's best if we hear from your other witness, and then we can ask questions at the end.
Yes, please. Now, Mrs. Maguire has presented a statement of evidence, but she would like to address you, and she knows there's a time limit, so she's put a lot of effort into getting this succinct for you. So here we go. I'll pass over
Thank
to
you. Ms. White.
Kia ora, my name is Heather Maguire, and I live in Tuakau. I'm chair of the community group Environment Action Tuakau Incorporated. I know the geography, topography, history, and community at Tuakau through research and anecdotally. So I know exactly where the Tuakau Proteins Limited TPL plant site is and how it is situated next to the Waikato River and within our community. I know the people in Lapwood Road, River Road, and Tyson Lane who have been badly affected by TPL in the past, as we have been in Alexandra Redart Road nearby. These people include family and friends. They have been largely shut out of the very complex process this hearing is part of, so I'm here to speak on their behalf. Life in Tuakau has improved significantly now that TPL has ceased operation. For instance, the swarms of seagulls which frequented the Waikato River to feed have disappeared now that the TPL plant is not operating. This is the expertise that I bring to this hearing. The Resource Management Act 1991 states in Section 6 that the preservation of the natural character of wetlands, lakes, rivers, and their margins, and the protection of outstanding natural features and landscapes are a matter of national importance. The Act lays out that its purpose is to promote the sustainable management of natural and physical resources while avoiding adverse effects on the environment. The submissions from TPL and Council are silent on this. I understand that the TPL site is zoned zoned business under current planning conditions. We don't want to change this. Although the site could easily be given a heritage or conservation designation, keeping the zoning on the site as business is the appropriate thing at this point in the evolution of the area, as it will allow the rapidly expanding communities of Tuakau, Pukekohe, and Pōkeno to benefit from their asset rather than have it closed to them. Very soon, thousands of people will have the gateway to the Waikato River at Tuakau closed to them if the TPL site is zoned industrial, halting business and recreational opportunities until the end of time at this environmentally important, historically significant, and potentially beautiful place. We don't want a change of zone here. The proposed Waikato district plan suggests the site could be an industrial zone. This is a short-sighted decision that ignores the interests of Tuakau residents, the wider community, and the future of the region. Please leave the business designation as it is. We wish to act for the environment, as encouraged by world-leading planning experts, who say all efforts to safeguard the environment and manage climate change are top priority. Sir David Attenborough, Prime Minister Jacinda Ardern, and many others at the highest spheres of influence are telling us this. I recommend a new book. You might be able to see it there. It's called Climate Aotearoa, What's Happening and What We Can Do About It. It's edited by former Prime Minister Helen Clark.
Ms. Maguire, we've got to stick to the issue here, and that is the rezoning issue.
Moving right along, sir. There are many more possible uses for this site as a business zone than an industrial one. Business zoning would allow for further development of Tuakau garden and wetlands, like Hamilton Gardens, which was once a tip and now a world-class treasure. TPL are able to move to much better sites next to abattoirs, where they can carry out their essential primary industry role expertly and in the sensitive way they need to reduce the footprint of agriculture on our precious whenua and to ensure business longevity in the rapidly changing meat consumption market. But would we want another factory in Lapwood Road if TPL were no longer there? Definitely not. Absolutely no. Residents have already suffered from smell, noise, dust, pollution, and truck traffic at all hours of the day and night for decades. The infrastructure surrounding the site is not suited to industry. River Road nearby is a major thoroughfare, and it is sinking into the Waikato with the existing use that it has. The old and narrow Tuakau Bridge has less than 30 years of life left. These are not appropriate conditions for the volume of truck traffic required by an industrial zone. At the moment, there is a sign on the Waikato River at the TPL Wastewater Outlet which says that swimming is not recommended there. Is this truly what we want for our waterways and our children? Tuakau Garden and Wetlands is the answer. This could be the next groundbreaking opportunity to be part of a mixed-use community development alongside the Waikato River, as the Te Awa Lake project near Hamilton will be. The land around the TPL site is sorely needed for people and can't be wastefully closed off in sensitivity zones, sterilising its potential. You good people have the environment and the economic future of Tuakau, Pukekohe and Pokeno in your hands right now. You have the physical and mental well-being of generations to come in your hands right now. Let all these people benefit from the business zone, which the site has at the moment, please, and not just one factory. Do the right thing and say no to an industrial designation on the banks of our Awa, the mighty Waikato River at Tuakau. Thank you.
Thank you, Ms. Maguire. I'll just see if there's any questions from the panel. Cedric?
Just a point that you mentioned, you suggested it could be a heritage site. Is there evidence of that?
Yes, there is, because it's next to the Waikato River. It needs nothing more than that. And also above the Waikato River at that point is the Alexandra Redoubt, which is a very significant historical site. And I do talk about that in my initial submissions. I talk about how affected this very significant historic place is by the industrial activity that TPL bring to the area already. So we have the Alexandra Redoubt, which is an amazing site. We also have the Tuakau Cemetery, which is
presumably they are not on the Tuakau protein site.
They are very close to it.
but not on the site itself.
Well, they couldn't be because the TPL site is a factory, and the Alexandra Redoubt Heritage Site is just above it.
Yeah. I don't have any more questions. Thank you.
Right, Ms. Gibb?
Yes, I just would like a question of Mr. Dawson. One of your comments, Mr. Dawson, was it's not about the zone, but it's about the performance standards that go with the zone. So I just want you to elaborate on that. I'm just trying to work out exactly what you meant.
Sure, thank you. Well, what I meant was that, as I understand it, TBL and perhaps even other submitters have submitted requesting a relaxation of the industrial zone noise standards so that they would be higher on the site, whereas the business zone standards as proposed are lower. And so what I'm really saying to you is that our starting point is that it's the rules within the zone which have the most profound influence and are of the greatest relevance because they deal with the reverse sensitivity concern. Does that answer your question?
Yes, it's what I thought you meant, that business zone has perhaps a higher limit. Well, I don't know if you want to call it higher or lower.
A more onerous noise limitation and policy background would be a better way of putting it.
Yeah, and that's usually because there are residents around a business zone that they're taking into account. Okay, thank you very much. That's all my questions. Thank you.
Thank you. Right, Ms. Tiaho?
No, thank you very much.
Mr. Mag?
No, nothing from me, thank you.
Mr. Fulton?
Yes, just thanks for your submission, and well aware of the comments that you've made. But you know, you've just heard that the Tuakau proteins have existing use rights, and also if they're complying with the current, it's not going to make them go away. But they've got the rights to continue there, and this is the difficulty, isn't it?
Well, look, sir, I understand that, but there's a very big difference between saying, well, you've got existing use rights. Now, let's be clear about what that means. That means that in terms of land use, not air discharge, they're entitled to operate within that consent to the same or similar scale, intensity, and character, and they're allowed to keep doing that. That's on one hand, whereas on the other hand, the district council saying, hey, we think this is an industrial activity, that an industrial zone brings with it an expectation of expansion of an industrial activity. It says, hey, this activity is appropriate here and it should be allowed to expand and be recognised. And that's a very different playing field, if I can put it that way. It encourages, if you like, we often hear, planners saying the zoning anticipates an extension, expansion of that kind of industrial activity, whereas existing use rights don't bring with them that same advantage. And that's really what we're talking about here.
Okay, thank you. Thank you for that reply.
That's right.
Thank you, Mr. Cooney.
All right. Mr. Dawson, just to get what Commissioner Gibbs said to you, is Tuakau, this is going by memory now, are they seeking a change to the industrial zone noise standard to make it a higher, or are they simply seeking the benefit of the industrial noise standard?
Ms. Williams might be able to answer this better than I can, and I wasn't at the hearing 7, but my recollection is that they were seeking a a slightly higher standard, and somehow dealing with the adjacent residential land. But to be perfectly honest with you, I don't recall the specifics of it.
All right. We'll maybe the 42A officer can expand on that in her reply, but just conduct is not relevant here, is it? In terms of what we need to do here, the tests that we have to undertake?
I take it by conduct you're referring to the prosecution and non-compliance.
Yeah.
Of TPL.
Yeah.
Yeah. Look, I legally I have to agree with you. And the court said, you know, on a number of occasions that is so. But what I think it does, so the non-compliances in themselves, I think, you know, you have to put to one side. But what I think it does highlight is that this operation, you know, has found it really, really hard to operate in such a sensitive location without creating, you know, significant, and forgive the pun, eye-watering odor effects on its neighbours. And I think that is a relevant consideration. You know, it's got you know, too big for its boots, so to speak. And that, I think, is really what the enforcement and compliance action around both noise and odour, because the district council's taken noise enforcement or compliance and monitoring action, I should say, as well. And it really says, hey, there's some, you know, there are some issues here.
All right. All right. No, thank you very much for that. Both to you, Ms. Maguire and Mr. Dawson. Thank you.
Thank you, panel members.
If you can ask the chairman to come back, please.
Thank you, folks. I've just got the message. Just see timing wise, I think Mr. Hall and Mr. Shuka, I think we'll hear from you before the break on behalf of Mr. Lynn at CHS Enterprises. Thanks.
Hello, Mr. Chairperson and Commissioners.
Morning.
Today we will be presenting on behalf of submitter 290 James Lynn, who owns 297 Dominion Road, and submitter 390 CHS Enterprises Limited, who owns 219B Dominion Road. To start with, I would just like to clarify that although we are presenting both submissions at the same time, and within the 42A report, the submissions were addressed together, these are separate submissions and should be assessed on their own merits. As you've made aware, all relevant documents have been read, so I'll keep this brief and address the main points we'd like to raise.
Thank you.
The first point we would like to address is in regard to the future urban zone. The original submissions were to rezone the rural areas on both sites to village. However, due to Hearing 6 introducing a village future urban density precinct for the newly zoned village land in Tuakau, and then the 42A report for Hearing 25 recommending that this land be changed to future urban, the relief initially sought may be different to the eventual zonings on the sites. We are therefore seeking rezoning to align with the future urban zone if this is what eventuates along Dominion Road. So to clarify, these submissions seek rezoning from a rural to an urban residential zone. The 42A report has expressed the need for structure planning within the area. We agree with this. We believe this will allow for a more comprehensive and integrated design for the development along Dominion Road. Paragraph 41 of Council's rebuttal has indicated that the most likely outcome if structure planning was applied to the sites would be large lot residential. This gives an indication that the land is suitable for residential development and answers the fundamental question, is the land suitable for urban development? I would just like to bring up a few images, if that's all right.
Yes, thank you.
So this image, the first image here shows that both the sites adjoin the extent of the proposed village growth area along Dominion Road, as you can see here. The next image is a figure 1 and 2 from our evidence and show that both sites are comparable to the adjoining site Zone Village or Future Urban in respect of location, state, scale, catchments, soils, landscape, and serviceability. So as you can see here from the different colours, they're pretty similar, and as well as down here to these other sites which have been rezoned to village, or been zoned village, sorry. Also, both sites can enable improved transportation and infrastructure planning, which will be explained further by Mr. Hall shortly. The sites are not subject to high quality soils, significant mineral resources, natural hazard areas, or significant infrastructure in which council are in agreement. By adding these sites to the areas of village/future urban zoned land to the east of the residential zone land along Dominion Road, it will contribute around 23% more land for future growth in this location. As a result, it is in our opinion that both sites can contribute to the development structure planning for the Dominion Road location. Moving on, we understand that the land currently zoned rural under the proposed plan on the sites are not located within the Future Proof 2017 or Waikato 2070. Council's rebuttal states that this is a key issue. However, both of these documents describe the urban limits of Tuakau as indicative, which is also referred to in Council's rebuttal. Therefore, to what extent do we rely on the indicatively mapped urban growth areas or higher order documents to define a particular growth area? As shown on various maps and images within our evidence and rebuttal, there are other areas outside the Future Proof 2017 and Waikato 2070 which have been zoned for urban development. This would suggest that there are limitations as to the weighting being given to these documents. I would now like to pass you on to Mr. Hall, who will give you go into a bit more detail about some site-specific concerns.
Thank you.
Good morning, Chair, and to the panel.
Morning.
I just want to start by just recognising that both these sites are indeed split zone sites. So both these sites have two parcels held in one title, and one of those parcels on each of the submitters' land is zoned to be village currently, or future urban, and the other is rural. Now, there's been no justification or relevant justification as to the need or the reason for this, and whereas we have submitted and throughout our evidence that there are some concerns, and I won't go into it, but they've been highlighted in our evidence to date. I'd like to also reinforce our response to the council's rebuttal evidence as to the extent of the village zone boundary on Mr. Lynn's property. I'll just share with you a map which was in the evidence that we submitted. Now, the council have identified that the extent of the village zone in this location is defined by a stream. When that's clearly not the case, the site has been mapped utilising the parcel boundary, which is the cyan coloured line that you can see. And the dark blue line that you can see is an indicative location of where the stream is taken from the Waikato Regional Council website. The actual location of that stream is slightly south, following that hedge line that you can see just to the south of the dark blue line. And yeah, it's very, as to it being a stream, it's all of about 0.5 metre to 1 metre wide. It's a very, very small. So that's just one thing we wanted to clarify there. I just wanted to move on to access and accessibility in relation to our submission sites. Now, our submissions have highlighted that improved access and accessibility is afforded by inclusion of the submission sites for both the submission sites and for neighbouring landowners whose land is zoned already, or proposed to be zoned village. I'll just bring up another plan to share with you. Now, this is a plan that is a wider zoom, wider scope. It shows both the submission sites and their relationship to the current proposed village zone land. If you can see, our submission sites have a dark black outer line showing the lot boundaries, and the properties to the south and west of those are shaded slightly yellow, and they represent the current proposed village or future urban zoning. So as you can see, the properties do immediately adjoin the extent of this zone. And just want to talk to you now about access and accessibility. Now, accessibility is not defined in the proposed plan, but it is actually a defined term in the Franklin section Waikato District Plan. And it refers to the extent to which land or any defined parcel of land is or would remain in an appropriate state of preparedness for accommodating a wide range of activities. Now, in this case, it's very relevant because we're looking at the transition or the interface between an urban zone and a rural zone. So accessibility considers characteristics such as the land and the locality, the parcel pattern of the existing lots, the topography, their aspect, and the relationships of the land to existing roads, any other potential roads or means of access, future access and land uses, and potential reverse sensitivities. Now, just in terms of, in my opinion, the shifting the extent of the boundary to include the submission sites as proposed, it creates the opportunity to improve access to housing within a natural catchment and enables the potential new roads and access connections to Dominion Road for urban living in a more appropriate location. Now, just on that, if you refer to the drawing in front of you, you'll see to the east of the site where the cursor is, there's a proposed road on our concept layout coming in here. Now that is a critical piece of connection there. It's an existing driveway in a very suitable location with good site access and visibility. And if we follow that road to the west and down past lot 20, you can see we've got some picked lines there which link and adjoin other sites that are either proposed village zone or obviously adjoin our submission sites. And this is the kind of access improvements and accessibility improvements that can be afforded by inclusion of these sites. So one other thing I would just like to show you on this is what's shown to you here are the concept lots for a 3,000 square meter net area village zone sites, which were unreticulated as that was what was originally proposed under the notified version. What I'd just like to bring up for you now quickly is a concept for an urban development of the site. There's been comment by Mr. Noth about the ability for servicing such a site. And I just want to refer to our evidence where we discussed the ability of the site to accommodate large lot residential type scenario, which under, where is it? Policy 6.15 of the regional policy statement talks about having 8 to 15 households per hectare, or 8 to 10 households per hectare. That equates to around about your site sizes of around 660 odd to about 1,250 square meters. And I can say with confidence that what we've got here is around 260 lots, and we're looking to have a range of between 220 and 280 lots. So we're sitting right in the middle of where it would be, and this is a bespoke design based on us having a good understanding of the site. So just thought I'd throw that in front of you to show you that there is definitely potential for developing these sites, and not unreasonably. Now, just want to move on from there to a defensible boundary. It's another discussion that's sort of in dispute. So following on from our access and accessibility improvements by the addition of these sites, there is the matter of what the configuration of the zoning extents will provide a more defensible boundary. We've evidenced throughout our submissions that these sites becoming an urban zone will provide a more defensible boundary, and council have tended to agree. Mr. Noth spoke this morning about the extent of the properties, these two properties reaching to a small ridge line, and that's the natural catchment that I'm talking about, and I continue to talk about. These two properties fall inside a natural catchment, which is for the most part taking in all of that area on our site, and then those areas to the west of our site and south to Dominion Road, which are already zoned or proposed to be zoned village or future urban or whatever the zone becomes. So in my opinion, having a good appreciation of the site, I've been across the site several times, and in view of this evidence that we've submitted to date, there are few areas on site where a boundary would be distinguishable and defensible between the land that's zoned rural and village on these sites, which is why the expansion of the zoning to incorporate all of these submissions sites area is proposed, and in our opinion will provide a more defensible boundary. Now, moving on to serviceability, which has been another matter that's been raised. There is continued question about the serviceability of these sites, and we have evidenced that both these sites are located in the upper reaches of a natural catchment, and that is the case. And that catchment includes that large area I just discussed. All of the area to the west of these sites and south to Dominion Road are in the same catchment, and those sites are proposed to be rezoned. So the services for things like stormwater and wastewater reticulation will simply be gravity-fed systems, the most economical type system you could have. There shouldn't be any requirement or any added requirement for pumps or anything like that. The wastewater and stormwater will simply just head downstream and be incorporated into the catchment. And so for that reason, the inclusion of these areas, and in particular through the structure planning process or servicing planning for the future, is quite simply very easy to add these sites to. There's nothing complex about it at all. In addition to those sorts of services, I also want to refer back to the potential access and roading services that we believe will provide better outcomes as a result of the inclusion of these sites, improved transport nodes, etc. In the last thing I want to talk to about is a very specific matter, and if I could just bring up an aerial overlay for you, which shows these sites. Now this is site specific to CHS Enterprises, and their property is the western property. So this is where I'm circling the cursor at the moment, is the main property, and also they own a half share in this access lot, which leads down to Dominion Road. Now, in this particular case, this property, if the rules remain the same, will become an isolated rural lot, in that it will be the only property having to access to what will become a new residential or urban area through new urban or residential roading. Now, I appreciate Dominion Road will also do the same, but Dominion Road is essentially going to become like a collector road for this area. It already is the main road. I can only ever see it becoming more of a collector road, and it will service some rural lots further to the west out here, which are not proposed to change in their zoning. But so Dominion Road will continue to be wide enough and be provided with enough form and formation, and so that it can accommodate a range of different uses and zones. Whereas the development of this land, which will be future urban or urban or whatever zone it becomes, it will be an urban environment, and generally speaking, you have narrow roads and you're in a residential location. And so the owner at 219B will have to access through a dominantly residential or urban area, and therefore they'll be quite isolated. They're the only property like this in this location that we're aware of. So this is one other reason why it makes sense to rezone this land. So those are the key specific matters I just wanted to raise with you, and I'd just open it to see if you had any questions for us.
Thank you both. Let's see how we go with questions. Ms. Sedgwick?
So my first question, what are the plans for the stream? I don't see that on your map at all. I presume it's piped and disappeared.
Plans for the stream in terms of the concept layouts we've provided? Yeah, so that stream, as I mentioned, is extremely small and is already, for the most part, diverted through. So through it basically runs through a channel or drainage system. So the roading, the potential roading and alignment would generally, I would see it as just running alongside it or continuing to run alongside a new road or alongside the road, and obviously it could be improved to help it's improve on its current situation. But it's currently just essentially a drained overland flow path, if you like. Yeah.
No, look, that's it from me for the moment. Thank you.
Thank you. Mr. Fulton?
Yes, just a question on if it was to be zoned village zone and then to convert village zone to an urban zone, and that's the intention of the village zone, and looking at how much land is available around Tuakau and your location there, realistically, it would be a long, long way into the future before that would ever be required to be converted to urban, wouldn't it? Be a long way out.
Yeah, I would suggest that it, as it is at the extremities of the growth, anticipated growth for areas, that a transition from a village or an unreticulated large lot type village situation to a higher density residential situation would be a longer term view for the development of Tuakau.
Okay, thank you.
Thank you. Ms. Tiaho?
I don't have any questions. Thank you.
Ms. Gibb?
No questions. Thank you.
Mr. Marg?
No, nothing from me, thanks.
Mr. Kearney?
No, thank you for your visual display. It's very helpful.
No, and I don't have any questions either. Thanks, gentlemen. It's pretty clear what you're seeking and why, so I don't have any questions. Thank you very much for your evidence and also your presentation today.
Thank you.
Cheers. I think we'll take our morning adjournment now, and we'll resume again at 11:25 with Mr. Sadlier and his team. Thank you. Well, thank you, everybody, and welcome back. I think we're due to hear from you now, Mr. Sadlier, on behalf of Tusen Limited and Tuakau Estates Limited. Thank you.
Thank you, sir. I'm conscious that we have quite a few people to get through and that we have filed a large volume of information which you've already read. So I'll try and keep this brief so that you can move on and hear from the witnesses as soon as possible. So in terms of my legal submissions, I won't read out the introduction or the statutory considerations, which you'll be very familiar with, having sat on so many of these hearings already. From paragraph 6, I deal with the National Policy Statement, Urban Development something which I am well aware you've heard from many submitters about already, and also have a large volume of material from the Section 42A authors on as well. I guess the one point to make after summarising some of the key themes from that document is that from the submitter's perspective, the rezoning request provides a small but important contribution to the reasonably expected to be realised housing supply in Tuakau and the broader Waikato area. So I won't go into any more depth in terms of that document because I'm sure you're very familiar with it and what it means and its implications for the Waikato district plan process. Moving on, I guess, to the key substantive issue, which is this one of reverse sensitivity. Again, I've set out in paragraphs 11 through 15 the principles that apply in terms of reverse sensitivity effects. Just saying it's not a matter where the industrial effects generator necessarily has carte blanche to do whatever it likes. It does have a duty first to internalise its effects if it reasonably can. The main concern is to ensure that adverse effects beyond the boundary are not unreasonable, that is, offensive, objectionable, significant, and assessing what is reasonable in the context of the environment beyond the boundary is relevant. Effectively, what we're dealing with here, and you'll hear from Mr. Hegley and Mr. Curtis shortly, is not really an issue of reverse sensitivity at all in our submission. It's more dealing with an interface effect in terms of whether there is compatibility between the two activities, being the industrial activity established in the Whangarata industrial area and what we're proposing in terms of rezoning of the land at 48 and 52 Dominion Road. In terms of noise, existing noise generated from the industrial area will comfortably comply with the operative and proposed noise standards, and there's no evidence to suggest there's a potential for reverse sensitivity effects which would otherwise be apparent given existing nearby uses. So to the west of the properties that we're talking about, there is already an established residential neighbourhood. Subject to the imposition of the amenity yard mechanism proposed by Ms. Hepplethwaite's Ms. Hepplethwaite's evidence in chief, and that's been updated in her summary statement after discussions with the planner for Mr. Shen and the site to the east. An appropriate separation between the industrial area and proposed residential uses is provided to appropriately minimise the risk of reverse sensitivity effect generated by residual emissions, and that's dealt with in Mr. Curtis's evidence. So he will speak to you in more detail on that. Mr. Curtis is satisfied that the scope of the council's discretion to consider a restricted discretionary activity consent for residential activities located within that amenity yard is appropriate and will enable proper consideration of dust, which, as I understand, the key effect here, and or odour effects. From paragraph 17 to 22, I deal with the issue of the scope of the submissions. It's not an issue that's been raised by anyone, sir. I just wanted to cover it off, as the amenity yard mechanism wasn't, I guess, signposted in the submission. It's something that's come up subsequently as a mechanism to deal with that potential interface. The case law, I say, establishes that when you're on a spectrum of relief and what you're seeking is lesser relief than that which you sought in your original submission, then effectively you're within the scope of your original submission. So I say that's the case here. This is lesser relief than a full rezoning of the properties without that amenity yard constraint placed on top of it. I then, in paragraph 23, just note that there were further submitters. None of those are raising any issues any longer. And so it seems that their concerns, at least in relation to these particular sites, has been addressed. And then in conclusion, simply make the statement that all things considered, the reverse sensitivity issue having been squared away from a Section 32 perspective, the relief we're now seeking is more appropriate than that in the proposed plan. So that's all I was going to address you on, sir, unless you have any questions.
I've just got one. Correct me if I'm wrong. There's no dispute now as between your clients and Ms. Tranau. Is that correct?
None at all, no.
Well, I think on that basis, we're content to take all the evidence as read and just ask your witnesses one by one if we have any questions. I mean, it just seems an awful, we've read their evidence. Them summarising it again isn't going to help us at anything, and it's just going to chew up a huge amount of time.
Certainly.
And as long as you're content with that, I think we'll proceed on that basis.
I'm comfortable with that, sir. And we did have everyone prepare, I guess, a highlights package, but on the basis that was only necessary if you wanted them to do that. So I'm very content for each of the witnesses to now proceed through and simply answer any questions that you have.
Well, I think that's the simplest way to proceed, and rather than just ask random questions and pick anybody up, I think if we do it witness by witness, there'll be at least some order to what we do. So that's what we'll do. So if you can just call the witnesses one by one, we'll see if we have any questions and we'll take it from there.
Sounds good. Okay, I'll have Mrs. Sen come and speak to you first.
Thank you.
Good morning, sir.
Morning, Ms. Sen. You might want to, we can see the top of your head, but not much else.
Oh, I'll tip.
That's better. Okay. Thank you.
So yes, I'm one of the directors for Tusen Limited, along with my husband. So we're a very close developed company. Okay. So, okay, we'll just wait for you to ask me questions.
Yeah, that's what we'll do. Thank you very much. Let's start with you, Mr. Marg.
No, nothing from me, thank you. Very clear.
Thank you. Mr. Fulton?
No, I think your argument's been satisfied by the report writer, so no, I don't have any questions, thanks.
Ms. Tiaho?
Yeah, I'm the same. Thank you. No question.
Ms. Gibb?
No questions, thank you.
Ms. Sedgwick?
No, I have none either, thank you.
Mr. Cooney?
No, thanks for the succinct way of presenting the case. Thank you.
Thank you.
No, and I have no questions either. Thank you, Ms. Sen.
Great, thank you.
Thank you very much.
Good morning, Mr. Chairman, members of the board. I'm the acoustic engineer.
Morning, Mr. Higley. Let's see if we've got any questions for you. I'm sure someone will have a tricky question for you. Mr. Marg?
No, not from I.
Ms. Sedgwick?
The Bollard Road industrial area, is that the timber yard?
Essentially, yes.
Okay. No, I'm fine. I'm located. Thank you very much.
Thank you. Ms. Gibb?
No, I'm fine too, thank you.
Mr. Fulton?
Yeah, Mr. Headley, what is the issue with the noise that would have been generated from the timber side? Is it the vehicle's movement, or is there another sort of a source of noise which needed to be mitigated?
It's plant itself. I've done extensive testing on the subject site, and they comply with their existing consent conditions, which are in actually fact more stringent than what we're proposing. So they will more than comply with what we're proposing.
Okay, thank you.
Thank you. Ms. Tiaho?
No, thank you.
Mr. Cooney?
No, the questions I'd asked Mr. Higley probably wouldn't be relevant to this matter. So no thanks.
Yeah, I was trying to put him on the spot too, just a bit of payback, but I can't think of anything. So thank you. Thank you for your evidence, Mr. Higley.
Thank you for not putting me on the spot.
Good morning, Commissioners. It's Andrew Curtis.
Morning, Mr. Curtis. Let's see if we have any questions for you. Ms. Gibb?
No, nothing, thank you.
Ms. Sedgwick?
I hate following the same line, but no, I have nothing either.
Mr. Marg?
No, neither.
Mr. Fulton?
No, thank you.
Ms. Tiaho,
No, nothing from me. Thank you.
Mr. Cooney,
Hi, Mr. Curtis, no questions.
and no questions from me. Thank you, Mr. Curtis.
Thank you.
I think at this point, sir, Mr. Hills is probably the relevant person for you to speak to, who's separately on this.
Yep, we can see Mr. Hills there. Thank you, Mr. Hills. Let's see.
Morning again, Commissioners.
Good morning. I have a feeling this will be somewhat repetitive, but let's see how we go. Mr. Fulton?
No, I don't have any questions for Mr. Hill. Thank you.
Ms. Gibb?
No, nothing, thank you.
Ms. Tiaho?
Not from me. Thank you.
Mr. Marg?
No thanks.
Ms. Sedgwick?
Just noting your your right turn bays, etc. Will those be easy to carry out without significant disruption to traffic using it for other purposes? So you talk about bridge widening and upgrades.
Yeah, there will be need to be some reasonable works in terms of some road works that can be, they're not unusual works by all means, and they will be reasonably, they're not going to be required straight away. They're going to be quite long-term works that will be required. So there will be some traffic management required, but no, I don't anticipate major disruption.
Okay. Thank you very much.
Thank you.
Thank you. Mr. Cooney?
No, thanks for your evidence, Mr. Hills.
No, and I'm in the same boat. Thank you, Mr. Hills. Thanks for your evidence. We have someone on screen. If you wouldn't mind, just for the record, introducing yourself, please.
Yes, Peter Alderton, Principal at ACH Consulting, Civil Engineer.
Thank you. Let's see if there's any questions. Let's start with you, Ms. Tiaho.
No, I don't have any questions. Thank you.
Ms. Gibb?
No, but thank you for coming along.
Mr. Marg?
No, thank you.
Mr. Fulton?
No, I have nothing. Thank you.
Ms. Sedgwick?
No, thank you.
Mr. Cooney?
No, thank you.
And I have no questions either. Thank you.
Thank you.
Tamarie, I'm Kath Heppelthwaite. I'm the planning consultant.
Thanks, Ms. Heppelthwaite. Just when you're ready. Oh, no, sorry, not when you're ready, when we're ready. Mr. Fulton?
No, thanks for the evidence, though. It was very well done. Thank you very much indeed. Thank you. No
Thank you.
questions, though.
Ms. Sedgwick?
No, nothing, thank you.
Ms. Gibb?
And no, just obviously a good job, well done by all. Thank you.
Ms. Tiaho?
No, thank you.
Mr. Marg?
No, thank you.
Mr. Cooney?
No, thank you.
And nothing from me either. Thank you. Thanks, Ms. Heppelthwaite.
Well, that's all from us, sir. I don't think there was much in that I need to address in closing, so that's our case.
Perfect.
Well, I think that's the first time in any of our hearings that the lawyer at the end hasn't had anything to say, but very unusual, but I can see why. And apologies if we've put folk to the effort of coming. We've had hearings very solidly for the last 2 weeks, and we haven't got together and asked if we had any questions. But we were also mindful of the fact that these things do evolve. So I know it may seem like a bit of a wasted journey, but I think it's appropriate that we at least do get the chance to conduct the hearing in public and to ask any questions if we do. But thanks for all your witnesses and for your client obviously bearing the cost of having everybody front up today. We do appreciate it.
Thank you, sir.
That brings us to the submission by Mr. Shen, please.
Good morning.
Good morning.
Right. So Mr. Shen owns the property directly to the east, 27 Tuakau Estates. It's basically the same issue of split zoning proposed by the submitter to cover the whole site with an amenity yard restriction as previously discussed. So I guess, do you want to do the same thing and just jump to questions?
I wouldn't mind if you could just repeat that, Mr. Shen. You're very faint, at least on my, and I'm not sure if the recording, I think I got the gist of what you were saying, but given that we are recording, if you wouldn't mind just repeating that, please.
Just seeing if I can am I clearer now, or should I come closer?
Maybe if you come a little bit closer, that might help, thanks.
Hi, just to repeat, I'm Aaron Gray, planner on behalf of Mr. Shen. His property is directly to the east of Tusen and Tuakau Estates land holdings, with a similar submission point being to rezone the southern portion from rural to residential. And during the evidence and in response to section 42, we also agreed to an amenity yard restriction, which applies to the area within 150 metres of the industrial zone, based off the evidence of Tusen and Tuakau Estates experts.
And just for the record and to confirm, there's no issue as between you and Ms. Trenuth?
Correct.
Thank you. Let's see if there's any questions for you. Ms. Sedgwick?
I've just disappeared myself. No, I have no questions. Thank you.
Thank you. Ms. Gibb?
No, nothing from me. Thank you.
Ms. Tiaho?
No, thank you.
Mr. Marg?
Nothing from me, thank you.
Mr. Fulton?
No, but pleased to see an agreement between both the parties, and no, I have no questions. Thank you.
Mr. Cooney?
No, and thanks very much.
No, and I don't have any questions either, Mr. Gray. Thank you very much for your time today. That brings us rather abruptly to the end of what was scheduled to be the morning session, and after a late start, we're 45 minutes ahead of schedule. Our next submitter is due to be Mr. Fuller's clients, Middlemas and Buckland landowners.
If I may, Mr. Chair, I'm just on the phone to Peter Fuller now. He sees his clients and himself won't be ready till about 1 o'clock, so we might need to proceed to Dallas or.
I just want to check. I don't want to put anybody on the spot, but is Ms. Tansley present? And if she's ready to proceed, that would be fine. If she isn't, we're happy to wait till after lunch.
It's Dallas calling. Can you hear me?
Yes, we can. Thank you.
If you could give me about 15 minutes, I would be ready.
Well, we don't want to unduly rush you. If you prefer to proceed after lunch, that's fine. Just whatever suits you.
Yeah, I've just landed, so I've just got to get to my venue and then I can call in.
We'll do it after lunch, I think.
No, I think we don't want to rush you, and coming back for one person's probably easier all round. I think if we just carry on as per our original schedule, if that's okay with you.
Okay, no problem.
All right. Well, we'll adjourn till 1 o'clock, and we'll commence then with Middlemas and Buckland Landowners Group. Thank you.
We're on, Mr. Chair. I think we're on a new Zoom, are we?
And I was just going to say, yeah, you'll need to log off this call and re-log on with another link that you'll see on the website if you don't have it directly. But if the panel wouldn't mind waiting just for a moment, please.